Many Canadians are exposed to serious health risks that are linked to environmental impacts every day. Small farming families might find themselves downwind from sour gas wells. Entire communities, like Sarnia, are drowning in industrial fumes. Southern Ontario is littered with energy projects that are driving people out of their minds and out of their homes. Circumstances like these almost always receive government authorization. They're legal. So what can people do? Environmental rights might help. The idea is that if something violates your legally protected environmental rights, then even if it complies with all of the rules and regulations, you can still fight back. But Canada does not recognize environmental rights. This hasn't gone unnoticed. You may have heard of the recently proposed Environmental Bill of Rights, or of David Suzuki's Blue Dot Tour, where he advocates for an amendment to the Canadian Charter of Rights and Freedoms to include an explicit right to a healthy environment. But for several reasons, these ideas are, at best, a long way off. This is where I want to contribute. I have conducted a legal analysis of environmental, constitutional, and administrative case law from all levels of Canadian courts, and I have found that there is a way to apply the Charter to environmental harms as it is currently written. No amendment, no new legislation. Specifically, we can use Section 7. Section 7 provides that if the government is going to infringe your right to security of the person by exposing you to serious health risks, then this has to be done in a way that upholds the principles of fundamental justice. One thing that fundamental justice requires is procedural fairness. And the minimum requirements of procedural fairness are notice, participation, and meaningful reasons for a decision. These are the core components of any sound environmental assessment scheme. Environmental assessment is proven to be one of the most effective tools available for preventing significant adverse environmental effects, and Canada is not doing it right. Section 7 can shake things up. It could constitutionalize the requirements of a fair environmental assessment when a project, regardless of size, scope, cost, or anything else, poses a risk of harm. And this hasn't been happening. So, while environmental rights are hopefully still on the horizon, this is an approach that is available for people with concerns like this to take action today. Thank you.